from the list.
You want adjournment?
No, Your Lordship, for being taken up. Serial number 75.
What is the matter?
The matter is with respect to reduction in the rank, Your Lordship. The petitioner was given the rank of Engineer-in-Chief cum Additional Commissioner cum Special Secretary, which has been taken away. And the rank was given pursuant to the order of this Honorable Court. And without any reason, they have taken away the rank and has posted in the Engineer-in-Chief, which is a non-cadre rank.
Counterfeit?
Sorry, Your Lordship.
Counterfeit?
Yes, Your Lordship, counterfeit.
Rejoinder?
Rejoinder has not been, nothing has been mentioned in the count. It
So
may be taken.
according to you, no rejoinder is required?
Your Lordship, my senior.
I don't know. You are mentioning.
Yes, Your Lordship, 75. I am mentioning it for being taken at the senior from outstation has came, Your Lordship, and therefore.
No, there is no problem. First you tell us that if the matter is ready.
Yes, Your Lordship, the counter has been filed. We don't.
You don't want to file any rejoinder.
Yes, Your Lordship. It may be taken up.
Come at 12 o'clock.
Obliged, Your Lordship.
Inform the other side. You have informed?
Yes, Your Lordship.
From supplementary list for orders, item 1, WPS 5677 of 2023.
There is a typing error in the order. What is the typing error? 4-3. Okay. This matter has been posted at the instance of the office. There is a typographical error in paragraph 3 of order dated 5/2/2004, wherein the date has been mentioned as 4/2/2024 instead of 4/3/2024. Accordingly, the order dated 5/2/2024 is modified, and the date in paragraph 3 is to be read as 4/3/2024 instead of 4/2/2024. Office to carry out the necessary corrections. Post this case on the prefixed date. There is a date fixed.
Yes, Your Lordship.
For face filing, item 2, WPS 4672 of 2023.
Well, at that page 56 of the interlocutory application, which was indicated by my lord on the last date, Lord, I have got some judgments of other high courts also, including, my lord, one of the Honorable Supreme Court. Although, my lord, that was not with respect to appointment of CAPFs by the Honorable Supreme Court, but it said, my lord, if the infirmities are such that it can be cured and it is not a permanent infirmity, that would not be a justified ground to refuse appointment only on the and on the basic issue of the Lord, presence of tattoo mark on the right hand dorsal side or posterior side. Lord, there are judgments of various high courts which says, Lord, that if the infirmity is of such nature that after surgical intervention or any other mode, if it can be removed, that should not be, my lord, a ground for rejection of the candidature of the applicant.
They have dealt with these conditions only?
Yes, my lord, specific, ditto.
No, this recruitment in CRP?
Yes, yes.
Show me one judgment.
I'll give you.
And show me that that particular clause has been dealt with.
Yes.
Which judgment do you want to rely
My
upon
lord,
first?
may kindly take.
Which one?
My lord, from the Rajasthan High Court Sayogita versus Union of India.
Rajasthan. Yes, please.
Yes, my lord, may kindly come to paragraph 9.
Just a moment. Paragraph number?
Para 9, my lord, may kindly see the particular portion of the recruitment guidelines is quoted therein. Exactly, my lord, the same condition.
Presently, the petitioner was not having any tattoo marks
No.
on the skin. This is the finding.
But yes, there, my lord, the review medical examination was conducted after, my lord, granting him an opportunity that if he so chooses, he may obtain the certificates from the my lord, recognized medical practitioners of a government college or a hospital and then apply for a review medical. My lord, in this case, the day when I was examined by the medical examination, detailed medical examination, on the same date the report was given to me and I was made to, my lord, fill up the form for applying for the review medical. I was not given any time
Need not.
to get it removed. My lord, we kindly see that.
And you see, just a moment.
Yes, my lord.
As per your interlocutory application, you got it removed prior to medical examination.
No.
Of course.
My
Just have a look at it.
my lord, the read petition.
No, you just
include an extra.
a moment, just a moment. You come to page number 115. When were you examined? Medically?
My lord, I was examined on 3/8/23 by the detailed medical examination. Sorry.
3/8/23.
By the review medical examination board.
3/8/23.
Yes,
Right?
and 2/8/23 by the DME.
2/8/23.
Yes.
You come to page 115 of your IP.
115. Yes, ma'am.
This is 6/6/23.
Yes.
So, whatever you wanted to do, you did.
My lord.
And you see, this is absolutely an afterthought. Because this is not your case in the writ petition.
True, my
You
lord.
have
that-
tried to make out a new case by annexing this document. You want an inquiry on this?
My lord, this document which has been.
It is absolutely a new case which you have introduced through the interlocutory application. You have not mentioned it in your main writ petition.
That was not happily drafted. That is there.
What not happily drafted, that's your fault.
That-
And your
it did
your
not-
client is not a person on the street.
It
No,
also
no.
did not contain the detailed medical
That's
exams,
right.
the guidelines
Need not
also.
be.
But my lord, I have enclosed the photographs also.
No,
from
we
page
are not
110
concerned.
onwards,
We are not
which
concerned.
indicates, my lord, the list.
They have, you see, you say that you had already removed it on 6/6/2023,
Right.
but still they found it unfit.
Right.
We cannot give you any relief under 226.
My lord, may I only pray, my lord, may I kindly refer to the orders. my lord,
I will
which
refer to
placed.
the orders.
That-
Certainly.
that will suffice.
One order is sufficient, or you have to refer all the orders?
My lord,
They are on the same line?
I'm sorry, my lord.
They are on the same line?
The Supreme Court order, my lord, that
Which one? Tell us.
Dharamveer Singh versus State of Uttar Pradesh. It was, although not with respect to the CAPF, but then, my lord, on the second page, my lord will find. It is true that the petitioner was examined twice over and was found to be medically unfit. However, considering the nature of ailment and medical condition, the issue appears to be remediable and not of any permanent character.
Where is page number?
My lord, on the second page of the Supreme Court order, that is Dharamveer Singh versus State of Uttar Pradesh, the second paragraph on the second page. So my submission is, my lord, this, that it was remediable in nature, and even the scar, it doesn't reflect, my lord.
So you have
the
already
tattoo mark.
remedied, as per your case, you had already remedied it
Yes.
prior to your medical examination. So there is a distinction, clear distinction.
Right.
Right. WPS number 4673 of 2023. This writ petition has been filed for the following relief. the counsel for the petitioner has submitted that the petitioner had participated in the selection process and he qualified in all the he participated in the selection process for appointment of constable within bracket GD in Central Armed Police Force within bracket CAPF S bracket close SSF comma rifleman bracket GD in Assam Rifle and Sepoy in Narcotic Control Bureau Examination 2022. It is in paragraph number 6 of the declaration. The learned counsel submits that the initial qualification, the petitioner duly qualified under the PST/PET test and was called for medical examination, and the petitioner was declared unfit only for the reason of tattoo mark on his right forearm saluting hand. He submits that initial detailed medical examination was done on 2/8/2023 and thereafter he was permitted to apply for review medical board,
Yes, please.
which
Was conducted on
was
3/8.
conducted on 3/8/2023 and ultimately the review medical board also declined the candidature of the petitioner for the same ground. The learned counsel has submitted that no sufficient time was granted to the petitioner to apply for review medical board by taking remedial step in connection with the tattoo marks. He has referred to the clause in the advertisement with regard to tattoo marks, which is quoted as under page number 56 of IA. The learned counsel has relied upon judgment passed by Honorable Supreme Court in the case of Dharamveer Singh versus State of Uttar Pradesh. In writ petition civil number 444 of 2019, decided on 19th July 2019, and has submitted that though the recruitment process involved in the said case was in relation to some other selection process, but it has been observed by the Honorable Supreme Court that though the petitioner was examined twice over and was found to be medically unfit, however, considering the nature of ailment and medical condition, the issue appeared to be remediable and not of any permanent character. The learned counsel has said that tattoo marks is also remediable and is not of a permanent character. He has also relied upon the judgment passed by the Honorable Rajasthan High Court, reported in 2023 SSC Online RAJ 3709 within brackets Sangyogita versus Union of India, and has submitted that in the said case also similar provision regarding tattoo marks was under consideration, and the Honorable Rajasthan High Court has taken into consideration that at that point of time the petitioner did not have any tattoo/skin art on her hand, and the mark/scar of her tattoo removal continues to be on her arm, due to which she has been declared unfit.
Para 11.
He has referred to paragraph 11 of the said judgment, which is quoted as under. from the perusal of the records of this case, it is apparent that the petitioner has brought on record a certificate issued by MS Skin and Hair Care Clinic as contained in page 107 of the interlocutory application, reflecting that tattoo removal was done by laser under topical anesthesia. Admittedly, in the present case, the detailed medical examination was conducted on 2/8/2023, and thereafter review medical examination was conducted on 3/8/2023, and still the petitioner was declared unfit on account of tattoo mark on his forearm. This court finds that this court is of the considered view that the impact of removal of tattoo mark and its the impact of removal of tattoo mark was essentially for consideration within the domain of the respondents, and this court cannot issue any such direction or make any such observation that the tattoo removal as per the claim of the petitioner done on 6/6/2023 was enough for considering the candidature of the petitioner and giving clearance for his recruitment. Even the photographs of such removal of tattoo marks has been annexed with the interlocutory application, and apparently the marks have not been totally gone. It is also important to note that in the writ petition which was originally filed, the petitioner had not raised any such ground that the tattoo marks stood removed prior to his medical examination, and such fact has been introduced for the first time only through interlocutory application by stating that prior to medical examination, the tattoo marks was already removed. There is no explanation from the side of the petitioner as to why such a fact was not indicated in the main writ petition. Even if the best case of the petitioner is taken into consideration, the tattoo marks have been said to be removed on 6/6/2023, still the candidature of the petitioner having been rejected twice on 2/8/2023 and thereafter on 3/8/2023. This court does not find any reason to interfere with the orders impugned, the orders passed by the respondents with regard to suitability of the petitioner in the detailed medical examination. Full stop. So far as the judgment passed by Honorable Supreme Court in the case of Dharamveer Singh versus State of Uttar Pradesh is concerned, it has been observed that if the ailment or medical condition is remediable and not of any permanent character, the candidature need not be rejected. But at the same time, in the present case, remedial measure having been taken to the by the petitioner as back as on 6/6/2023, and whether the remedy was actually done it was essentially for the respondents to examine, which they have examined subsequently on 2/8/2023 and 3/8/2023 and rejected his candidature. So far as the judgment passed by the Honorable Rajasthan High Court, reported in the case of Sunny Jovita is concerned, the same judgment also does not apply to the facts and circumstances of this case, wherein the Honorable Rajasthan High Court has recorded that the petitioner of the state case did not have any tattoo/skin art on her hands. In view of the aforesaid facts and circumstances, the presented petition is hereby dismissed.
One humble prayer, my lord. One more judgment, if my lord may kindly be pleased to
I
refer. my lord.
I have given you enough.
That Rajasthan High Court, Punjab Haryana High Court.
No, that's all.
My lord, for the satisfaction of the client.
No,
my lord.
we are not here to
Because I
satisfy
have
your
for-
clients. You
No,
just
no.
see the conduct of your client.
My lord, my lord.
Yes.
Only for a
Your
moment.
conduct
my
is
lord.
also equally
Only
important.
for a moment, my lord.
We
The
have had
Punjab
enough.
and Haryana High Court
We
judgment.
have,
my lord.
you see, I have heard you.
My lord.
I have dictated the order,
My lord.
and after the dictation of the order, you cannot insist upon citing any further.
No, not further, my lord.
No.
The three judgments
Yes.
which I had placed
Next,
only.
call next.
Lord,
Item
give my
three.
name, Lord.
Done
Give
case
your
4936 of 2023. Along with item 4.
Yes.
The petitioner herein has prayed for consideration of a candidature which has been rejected on grounds that they were not aware of the publication of result. May I take your ladyship to only few documents, your ladyship? and-
I have understood. You just tell us. You come to page number 90. You were
Yes.
absent on the last date.
Yes, your ladyship.
Page 90.
Yes, your ladyship.
All the communications are to be through website.
Yes, your ladyship. May I may only try to distinguish my case if your lordship may give me opportunity?
Certainly.
I'll just try, your ladyship. I'm aware that this is a weak case. Your lordship, two things I want to point out. Annexure 1, page 42.
Yes, 42.
Annexure 1, page 42. This was the advertisement, your ladyship, wherein an email address was provided. Email Jharkhand _SSC@rediffmail.com. Your ladyship may kindly have annexure 4 series for the moment. Annexure 4 series starts from page, 3 series from page 110, your ladyship.
Yes.
110. So all the communications which were made to these petitioners were made via this email.
From where do I get that this is an email communication?
Yes, annexure 3 series, your ladyship. Dear Ramesh Kumar, and your lordship may see this is from noreply.jssc.com.
Page 100,
110,
110.
110, annexure 3 series. So all these petitioners were communicated. If your lordship, ladyship may kindly see forwarded message from noreply@jssc.com. I'm only trying to persuade your ladyship that the entire procedure that was adopted, even in the advertisement, it's written online mode. And all the communications were made to us through email from JSSC. We received the entire email. The last email that was received to us was in 2017, in the year 2017. Suddenly,
And what is this email 2023?
2023, there was no email.
This is 2023 email 110.
No, your ladyship may kind that was
August 28, 2023.
that was given to my office, your ladyship, just to show that this email was forwarded to us. Your ladyship may kindly see niche forwarded message from no reply, date 31st December 2017. That was sent to the advocate, your ladyship, in 23. But the main portion is December 2017.
Where is the mail received?
By the clients.
Yes. This
From-
is it.
Yes, your ladyship. The client forwarded
Application sequence number.
Yes, your ladyship. Application sequence number in 2017. The candidates received an email form. Thereafter, the next message also.
You see, it is a password protected communication, and therefore this communication was through email. Nobody else can have an access to it.
Other emails also, your ladyship, may kindly have page number 111. That also was received to us by an email. Other informations also. Login application form, application number, DOB, everything that was communicated to us through email, your ladyship.
Okay.
And in the advertisement also itself, it was given everything would be done online. I'm only trying to communicate it after suddenly, after 2017, in the year 2023, after passage of law year, the results were published on the website. Now, your ladyship was on that clause 10, page 90, clause 8. परीक्षा से संबंधित सभी सूचनाएं आयोग के वेबसाइट पर दिया जाएगा. Thereafter 10, clause number 10 में kindly listen. अभ्यर्थियों की जानकारी के लिए परीक्षा के परिणाम प्रकाशित होने के बाद अभ्यर्थियों का अंक आयोग के वेबसाइट पर अपलोड किया जाएगा. So there is an ambiguity in relation to what will they actually upload when the entire event was taking place via email.
परीक्षा से संबंधित सभी सूचनाएं, is that not sufficient?
परीक्षा,
everything?
the ambiguity what I'm trying to inform your ladyship is that कि परीक्षा में भी the date change, परीक्षा प्रमाण पत्रों से नहीं था कि परीक्षा का प्रमाण पत्र वेबसाइट में अपलोड होगा. They said परीक्षा के बारे में. So there is a gray area. परीक्षा के बारे में मतलब उनके date changes उनके बारे में या उनके उस परीक्षा के बारे में.
That's right. Yeah.
That is only I'm trying to inform. And just one more. In the counter affidavit, your ladyship, they have taken us to a judgment of Basanti Kerketa. That gets distinguished from our case only on the point that in Basanti Kerketa had taken a plea that because she lives in a remote area, she doesn't have access to online mode. She lives in a village. So, and my
That
case
is not the distinguishing feature. The feature
my
is
case,
something
I was requesting for an online mode. I was requesting that if an email would have been given to us, कि this has been uploaded on the website.
Was email given to her?
No, that is for a different thing. Email.
Email was not never given to Basanti.
That is what I'm praying that, and if they were doing everything by email, they could have just said that the results have been uploaded. That is only my case. If they're doing entire thing on email, and that is why I brought on record the email messages that were sent from the commission unit. And there are two clauses, 8 and 10.
It is arising out of the same advertisement.
Same.
Basanti Kerketa.
Yes, you need. I thought Basanti Kerketa was from
Yes, 21 of 2016.
21 of 2016, same. So there she was pleading that I should have been given a post. The result should have come to me on post. I am saying that I don't require a post. When you have said in your advertisement that everything would be online, you have sent me emails. Even the advertisement on the very page 1 consists of an email ID. All the entire thing in 2017 has taken place by email. Why email? Only my prayer was they could have informed that the results have been uploaded, and in clause 10 it is specifically stated कि प्रमाण पत्र अंकों को अपलोड किया जाएगा. So there is a gray area.
questions, sir? Yes, what do you have to say?
I'm from the state.
One more thing, if I may be allowed to add. In the second case, I would be there.
Will argue your case also.
Yes, ma'am. And that's
Just, I'll conclude, Your Ladyship. Just had they not sent us an email, we wouldn't have had a case, Your Ladyship. The only thing that initial communications all were made by email. There was an expectation that email would be sent to us, and in clause 10 it is said कि अंकों को upload किया जाएगा. And अंक
You
has
are
not-
repeating it.
हाँ, that's all.
Just a moment. Let him also complete.
let's two things that in the second writ petition, you'll also find at page 14. I've quoted one judgment and page 15. Para 27 and 28, my lords. I may read that. It was a judgment that was passed in RF Jain versus the state of Bihar, the Bihar Public Service Commission. It stated that non-production of the original
Other, repeat the other record also. There are two cases.
C04.
Yes, what is it?
It says that non-production of the original certificate at the time of the interview is not a sufficient reason to reject a candidature of a candidate who was placed in a merit. Now, what has happened? There is one judgment of this honorable court also. I have just supplied. That is passed in the case WPS number 3084 of 2019.
Where is that?
So I have just sent it to the court master.
Sent it means what?
I'm just requesting him to give a copy to you. I was not having a
Is he
copy.
supposed to take print and give the copy?
Never.
This matter was adjourned in your presence? Then
वैसे सुबह अभी just मुझे भी मिला है तो I just thought it would be better that
it is already almost 10 past 11.
just 5 minutes back I received.
5 minutes back you have
Yes.
received. Then I'm sure you must not have read it also
No, I have read it.
in 5 minutes.
उसके बाद भी
Read
हम
it,
सोचे
overdid.
no. Let's
Don't ever do it.
Yes,
Our stationery are not meant for you.
I understand.
Yes.
So in this, my lords will kindly take pain to read paragraph 2. Through the counter affidavit have been filed on behalf of the state respondents and joint of the same has also been filed by the petitioners. It has been jointly submitted that by the learned counsel of the parties that the present replication may be disposed of in light of the judgment dated
So what do
2
you want to say?
My lords, I say that in terms of the judgment rendered by the Honorable Supreme Court, the JSSC has still prepared a state-wise merit list thereafter. I am only saying, my lords, if they can show that I am not finding place in the merit list now, because this is of 2019 that the communication
The
was
time
made.
was granted for 3 months only.
Lords, I am only saying if they can
I
show.
just want to know.
Yes.
Only 3 months time was granted. Now, in the case of Sanjeev Kumar's, where is the judgment of Sanjeev Kumar? You have not brought that. So it is for us to get the judgments for you. You are smiling.
No, my lords.
Your client must be watching you.
That is my mistake that I am smelling on my mistake.
You show her in the counter affidavit file in that case. Page number 28 of the contract. This is the observation of the Honorable Supreme Court. It is also made clear that High Court shall not pass any contrary order with respect to the recruitment in question. Now, if we allow your candidature now,
My lords,
after no,
I'm not requesting that, my lords.
then what is
I'm
our
only
what are you
saying that
requesting?
if the merit list have been prepared thereafter, I find a place in that.
I do not know whether
Plus-
you place, find place, not find
Plus
place.
in the other
There
case,
is a clear direction
Yes,
that
ma'am.
High Court shall not pass any order. We will not pass any order.
No,
We
lords,
go to the
they
Supreme
were to
Court.
prepare a merit list.
No, you explain this. And how do I come, how do I cross this observation of the Honorable Supreme Court?
Lords, there is a very clear indication.
No,
in
you
the
just
judgment that I was reading.
stick to that observation of the Honorable Supreme Court and tell me that how do I clear that hurdle?
My humble request is that I'm not
No request,
seeking.
no. This is order absolutely legal. You just tell us.
Plus, I am only saying
The
that they have
judgments of
already
the Honorable
prepared
Supreme
it.
Court might not be binding on you, but it is certainly binding on
What
us.
I'm trying to convince my lords is that they have already prepared a list. I'm not asking for challenging or changing that list now. Pursuant to the order of the Honorable Supreme Court, they have already prepared it. They may say it before this court that whether after the thereafter when the list was prepared, my name features in that list
We
or
will
not.
not say anything.
Plus,
We will
because
not
they
say
have to
anything
prepare
because
it.
pursuant to whatever was indicated in the website, you had not participated.
That is true, my lord. That stands like in the 2019 it was the status. Now it is in 2023 that the Honorable Supreme Court already passed an order.
We
They
do
have
not.
already passed, prepared a merit
Whatever,
list.
whatever extension of time, further participation, whatever you have to say, you have to go to the Supreme Court. I will not pass it.
But I am only requesting
No,
to a
you
very
see,
limited extent.
Even for a limited extent, when there is a clear observation of the Honorable Supreme Court that High Court shall not pass any contrary order, then how can I
Plus, your
pass
lordships
it?
will not pass an order. The thing is that if they have already prepared
No,
it
please no.
and my name features,
No.
they will just have to say it to the Honorable Court that my name features or not.
You could have sought information under RTI. We are not here to ask them to
Lords, in the
fill up
other
your...
cases, may I apprise this court about one of the things, my lords. In the other cases, they have prepared a list wherein they have stated very clearly. Other cases, I say, my lord,
I do not
that
know.
this
You
was
see,
the last cut
things
of date
which are
and my
not
name
on
features
record,
on.
things which are not on record, I cannot say anything. The fact remains that whatever was the
Then,
timeline
my lords,
prescribed in the website,
May I
you did not
request for
participate.
only one thing, my lord? Let it be in the second half
No.
because there are many cases
No,
where
I am
they have.
hearing you for 15 minutes. No.
Only to that extent, my lords, to convince your
Many
lords.
cases means what?
Many
Is there
cases,
any final decision of this court? No.
they have to take a decision.
No. Court has to take a decision when you have come to the court, whether we will issue mandamus or not. If you want them to take a decision, you withdraw and pursue. We don't have anything to
Not
say.
regarding that. Whether we are featuring in the list or not.
No, we are not going to ask them for anything. You did not participate pursuant to whatever was uploaded in the website, and in view of clear observation of the Honorable Supreme Court that the court is not going to pass. High Court shall not pass. You see, it's not a general kind of observation. And this generally we do not find in judgments passed by the Honorable Supreme Court. Honorable Supreme Court must have thought something, applied its mind. That it cannot be a never-ending process,
But-
and people
But
enter
the
into
two judgments
litigation
are
and
to
the
be looked
entire
side by
process
side,
is...
my lord. Because in the other judgment, they were to prepare a list. They have prepared it.
That's it. I have heard you.
Yes.
Okay. Learned counsel for the parties are present. This petition has been filed for the following relief. These two writ petitions, right? WPS number 5768 of 2023 with WPS number 4936 of 2023. These two writ petitions arise out of the same recruitment process, that is advertisement number 21 of 2016. And therefore they have been tagged together. The terms and conditions of advertisement has been annexed in WPS number 4936 of 2023, and a counter affidavit has also been filed in the same case, and therefore but the terms and condition of advertisement and counter affidavit has not been filed in WPS number 5768 of 2023, but the issues are identical. Then you quote the relief, right? In WPS number 4936 of 2023, following prayer has been made, and in WPS number 5768 of 2023, following prayer has been made. In WPS, the foundational facts of WPS number 4936 of 2023 are as under. The petitioners had participated in the selection process pursuant to advertisement number 21 of 2016 for appointment of teachers to the post of combined graduate trained teachers in different subjects and districts. The petitioners had received communication via email from Jharkhand ssc@rediffmail.com titled Application Login Details, and also received further communication through email, and they were also informed through email titled Admit Card Download Intimation for Combined Graduate Trained Teachers Competitive Exam 2016, that their admit cards have been uploaded against their application number. Finally, they were allowed to appear in the examination held for compulsory paper on 19/11/2017 and Sanskrit paper on 25/11/2017 at their allotted center. And after the said examinations were held, an email from noreply@jssc.com was received by the petitioners informing that their registration for JSSC Form 2017 has been successful. None of the petitioners received any communication/information from respondent JSSC between December 2017 to April 2023 regarding their results or their being shortlisted. And all of a sudden, in the year 2023, they came to know that eligible shortlisted candidates have been asked to go to Nagpur Ranchi for counseling and document verification. Whereupon, on checking JSSC website, petition number 1 and 2 found that by notice dated 11/5/2023 and 30/5/2023 respectively, list of candidates shortlisted against vacancy of direct recruitment was posted on the website, by which among many roll number by which the candidates were called for verification of their certificates/documents. Your roll number was also there? Your roll number was there?
Yes.
My roll number was there.
There are only 2 roll numbers mentioned.
Four.
No, it is page number 18, only 2 roll numbers are mentioned.
And then I'll show you. So 4. 2 roll numbers, and then page number 19, second paragraph, 2 more roll numbers.
Okay. The roll numbers of the petitioner number 1 to 4 were mentioned in the website, and they were shortlisted candidates. How is it that they were called on 7/12/2022?
There are 2 lists in addition. I'll show the list. Page number. Annexure 4 series, page 120. 120.
120.
The first was published on 3/11/2022, one list, page 120.
3/11/22.
3/11/2022, and on page number 121, second sitting, petition number 4, roll number is there, second sitting, extreme left, the second column, second from the bottom in the second sitting.
No, it is mentioned 35/2023 at page number 127.
That is of page number 127. Page number 127, the 4th is that was 35/2023. 4 days.
Where is 3/11/2022?
3/11/2022 is page 120.
The petitioners by different representation to respondent JSSC requested that due to non-communication of information to them regarding counseling and document verification held by respondent via any mode, that is letter, mobile, email, phone message or any other manner, they could not appear before JSSC on scheduled date. And they requested for allotment of another date for counseling and verification of the documents. But no response was received from JSSC. And ultimately, the present writ petition has been filed. It is the specific case, it is the case of the petitioner during the course of argument that when various communication earlier were received through email, the respondent JSSC ought to have sent individual email to the candidates instead of publishing the same in the website. And consequently, and on account of such action on the part of the respondent JSSC, the petitioners have been deprived from participating in the counseling, and therefore they are seeking a mandamus from this court so that they could also participate in the counseling process. The Learned Counsel has referred to the advertisement and submits that the email address of JSSC has been mentioned at the top of the advertisement, and so far as clause 4 within bracket G within bracket Roman 8 is concerned, though it provides that all the information regarding the examination would be uploaded in the website, but at subclause 10, it has been mentioned that the final the final marks of the examination would be uploaded in the website. The Learned Counsel submits that there is a gap, and therefore the communications having been made earlier through email ought to have been made through email, and consequently the present writ petition be allowed. The Learned Counsel appearing so far as WPS number 5768 of 2023 is concerned, it is the case of the petitioner that she had also participated in the selection process arising out of advertisement number 21 of 2016 and fulfills all the criteria. She was issued the admit card and applied under the category of scheduled caste for Hindi subject. She participated in the selection process and submitted all the relevant documents in support of her candidature. And by terms of notification dated 2/4/2019, she along with other candidates were declared successful. And were to submit all the relevant documents on 9/4/2019. The petitioner being unaware of the fact that the result could be published in such a random manner, and also owing to her personal difficulty was unable to check the website of JSSC, and as such the notification dated 2/4/2019 was not in the knowledge of the petitioner. It is her further case that the petitioner, being a lady belonging to scheduled caste community residing in a remote village in Dhanbad, far away from regular internet facilities, and has access to internet only seldom when she visits internet cafe. And therefore, the petitioner is seeking a mandamus from this court